MCIA event in Mumbai as a part of the third edition of the India ADR week, which celebrates and promotes alternative dispute resolution and its profound impact on India's legal landscape. I am Ishani Vora, a senior director in FTI Consulting's disputes practice in Mumbai and a co-chair of the Young MCIA steering committee. I, on behalf of my other co-chairs, Gathi, Shreya, Ali Park, and the entire Young MCIA steering committee, would like to thank you for making the time, for being with us here today. And a special thanks to everybody who has flown in from various parts of the country and various parts of the world to join us. In a world where borders are becoming increasingly porous, businesses are expanding globally, and the need for fair and efficient resolution of cross-border disputes has never been more critical. International arbitration serves as a beacon of hope, a mechanism that bridges diverse legal systems and cultural differences for the resolution of disputes. It is in this context that MCIA functions and has organized the ADR week yet again. Young MCIA, an integral part of the MCIA, is a group of like-minded and driven ADR practitioners dedicated to advancing ADR in India and beyond by nurturing the next generation of professionals like many of you here with us and encouraging them to build expertise, foster robust networks, and share experiences. Ever since its launch in 2017, Young MCIA has been striving to be at the forefront of bringing change and growth to ADR in India with its fresh perspective, innovative ideas, and wholesome energy. In association with international institutions, Young MCIA has conducted training sessions for emerging professionals and law students on ADR. It has also organized events, competitions, and initiatives to promote and deepen the conversation on this topic. This evening, Young MCIA has organized two very interesting discussions on contemporary and thought-provoking topics. First, we will have a panel discussion on the topic resolving disputes with the government and state-owned entities through arbitration, best practices and effective strategies. This is a pertinent topic, especially given the geopolitical and economic dynamic in the country, the significant upsurge in India's infrastructure initiatives, and the increased attraction of foreign investment. These conditions will continue to also expose businesses to a great deal of contentious cases in the fields with significant government intervention and involvement. In this panel, experienced speakers will share their views on the best strategies to most effectively contribute to the resolution of such contentious cases. Next, we will have a debate on the topic Indian court's contribution in making India the next arbitration hub. Is it a step forward or backward? Where on one side, we will have arguments emphasizing the vital role of the courts in fostering India's arbitration landscape. On the other side, we will explore whether the court's actions cause hindrances in achieving this objective. I hope this debate will encourage a meaningful dialogue, since India's future as a global leader in arbitration depends on how the judicial system facilitates arbitrations and helps parties and the ADR community. I would like to end with a quick note. To our young professionals in attendance, I encourage you to seize this invaluable opportunity to learn from the wealth of knowledge in this room. Engage in discussions, ask questions, and build connections that will fuel your growth and development in the ADR field. Your energy, creativity, and drive are the forces that are shaping the future of international arbitration. And to our esteemed senior professionals, your mentorship, guidance, and experience are invaluable resources for emerging talent. We are grateful for your presence and your willingness to invest in the next generation. Your insights and wisdom serve as a guiding light for those who are just embarking on this journey. On this exciting day of discussions and networking, let us remember that the strength lies in our collective commitment to the field of international arbitration. Young MCIA is more than just a community. It is a force that is collaborative and that wants to push boundaries of what's possible in ADR. Without further ado, I'll hand it over to Gathi to proceed with the panel discussion. Thank you, everyone.
Good evening, everyone, and welcome to the MCIA panel discussion. Without further ado, let me introduce you to the stellar panel we have today. We have with us Mr. Narayanan Iyer, who heads the legal department of Hindustan Petroleum Corporation Limited as its executive director legal. He joined HPCL in the year 1985. His vast experience spans 3.5 decades of handling all kinds of legal matters in the oil and gas industry. This includes drafting and negotiating JVs, EPC contracts, project finance and loan documents, managing litigation and arbitration. He must have handled over 100 arbitrations till date. Mr. Iyer is also a cost accountant and a company secretary, and in addition to a law degree, he also holds a master's degree in international banking and finance. Welcome, Mr. Iyer. Mr. Oswald Dsouza graduated law from Mumbai University in the year 1990. Mr. Dsouza began his practice at the Bombay High Court, and after a few years, he moved in-house with a consumer durables company. He joined the corporate legal department of L&T in the year 2000. Since then, he's acted as legal head for the shipbuilding, defense, nuclear, and heavy engineering businesses of L&T, and is currently the group legal head for L&T's energy hydrocarbon business and wind farm business. He has extensive experience in handling transactions, disputes, and mergers and acquisitions in various industry sectors such as hydrocarbon, power, shipbuilding, nuclear, defense, infotech, finance, and a couple of others. Welcome, Mr. Dsouza. Ms. Zarina Chinoy graduated law from Government Law College in the year 2001. She also holds a master's degree in international business, trade, and tax law from the University of Houston. She's a qualified solicitor and is also licensed to practice in India, Texas, and New York. She's currently General Counsel EPC Division at Shapoorji Pallonji Group. She's a skilled negotiator of construction and finance contracts, whether FIDIC or bespoke, and also handles dispute resolution. Welcome, Ms. Chinoy. Ms. Bindi Dave. She's a senior partner with Vadia Gandhi & Co. She handles the firm's disputes practice and specializes in corporate commercial litigation and arbitration, both domestic and international. She also acts as an arbitrator in commercial arbitrations. She represents domestic and foreign funds and other clients in disputes involving private equity investments, shareholder litigation, constitutional litigation, infrastructure disputes including highways, toll, water augmentation, among others. Apart from being an AOR in the Supreme Court, she regularly appears before the Bombay High Court, arbitral tribunals, the NCLT, NCLAT, etc. Welcome, Ms. Dave. And finally, we have Mr. Gaurav Gulati, who is a partner at Accuracy. He joined Accuracy in 2015 with over 20 years of experience. He has acted as a damages and quantum expert in various arbitrations and specializes in transaction and disputes advisory work. He regularly provides evidence on quantum, financial, and transaction disputes. He's led various domestic and cross-border M&A transactions and private equity fundraisers for clients across industries and geographies. He started his career in 1998 with Ernst & Young in the Middle East. Later, he moved to Canada to work with Allianz Insurance and gained significant finance experience in the North American market. Welcome, Mr. Gulati. My first question for this panel is for Ms. Bindi Dave. Ms. Dave, the government is making attempts to strengthen India's position as a favorable jurisdiction for arbitration. For example, the Arbitration and Conciliation Amendment Acts of 2019 and 2021, as also the India International Arbitration Center Act of 2019, which is aimed at promoting institutional arbitration in India, and to promote India as a hub for international arbitration. In your experience, what are the advantages or disadvantages of institutional arbitration vis-a-vis ad hoc arbitration when resolving disputes specifically with the government and or its instrumentalities?
Hello everyone, hi, I'm audible, my speaker's working, right?
I can hear you clearly.
Okay, so thank you first for having me here. And arbitration per se is a topic of great interest to me, because I'll start by telling you this, that I cleared my law in 1996, and our Arbitration Act is of the year 1996. So I somehow feel that I have kind of grown with the Act, and I have tried to do as much arbitration, could have come my way, and I could have done it. So in that sense, well, I'll start by saying that we still in India have a long way to go in terms of resolving all disputes by arbitrations, because our contracts, all of our contracts still do not have arbitration clauses. So there is still a lot of litigation work that is happening. And therefore, it's not that one could dedicate, just purely an arbitration practice. So we do have a, healthy bit of both. But I have tried to do as much arbitration as I can. And to answer your question, Gathi, in terms of ad hoc versus institutional, obviously, as everyone knows, institutional arbitration is still yet to catch up. Everything, or at least all the earlier contracts, did not have, the institutional arbitrations as arbitration centers as, the preferred mechanism. And there are several reasons for it. To start with, I think there's a misconception that institutional arbitrations turn out to be more expensive, which is actually, as I said, a misconception, and people are just about beginning to realize that. One would have to do actually a compare between an ad hoc arbitration and an institutional arbitration to be able to understand the difference. But as I said, it is a misconception. Second, we do not have that many arbitration centers as yet. And for those parties who provide for institutional arbitrations in their contracts, that's an elite lot who understands the importance. So as a result, you end up having still, because what most of us don't realize is that when contracts are drafted, very least amount of attention is paid to dispute clauses. It's like a honeymoon period where nobody wants to think of a divorce. And therefore, very often we have very confused and complicated dispute clauses. Fortunately, in our firm, we have a very healthy interaction between the corporate team and the disputes team. And whenever you have a concern on what to choose and all of that, and we are there to guide them. But I don't think that happens everywhere. And as I said, most people don't realize the importance of it. Now, these days, you see most of the contracts having institutional arbitrations. But if you ask me the reason or the advantage or disadvantage, as I said, firstly, people are under this misconception that it is very expensive, which it is not. Second, and most important, is that all these institutions have rules. So there's a prescribed procedure. While, of course, our Arbitration Act also, in that sense, does have some sort of a procedure set in. But having institutional arbitrations always sets a proper regulatory mechanism. There's a proper rules in place, which in ad hoc is, as the name suggests, ad hoc. And if you have sensible parties and advocates representing both sides, then yes, then even in ad hoc, you can have a sensible procedure. But unfortunately, when parties are in a dispute stage, the defaulting party, if I may say so, is not always very cooperative and, will always look at ways and means to delay and drag and defeat the process. And therefore, that's the other reason which I feel, is very important and which parties don't realize to start with when they are, drafting the clause. And of course, in terms of arbitrators, most of the institutions have a very eminent panel, eminent arbitrators on their panel, which, in ad hoc is kind of ad hoc as the name suggests. It will be left to parties to decide. Also in terms of costs, in terms of arbitrators' fees, MCIA for sure has some sort of a cap, and it's regulated in that sense. Also a lot of assistance is rendered. So I feel all those advantages are there in the institutional arbitrations, which parties are now beginning to realize. And of course, so the new contracts that you see as we speak today, most of them would have institutional arbitrations. But the earlier contracts when, this was not well known and the advantages were not known, we still see a lot of contracts with ad hoc clauses. So I'm not sure whether that answers your question, but did you have anything else specifically which you would have liked me to address?
I think that was perfect. Anything specifically insofar as government and state-owned entities, instrumentalities, in that context of arbitral versus...
So all the more, I think in the contracts where government is a party, we've not seen, we've yet to see, okay, let me rephrase that. Not all contracts to start with have arbitration clauses. And even in the ones that have arbitration, it's not hardly ever you'll find an institution specified. Though Maharashtra government now has a policy in place and is highly recommending incorporating the MCIA as the institution. Of course, it's a suggestion. So Maharashtra government, definitely I'm seeing that, but that's as we speak, it's happening now. But if you, and normally disputes would arise in earlier contracts, so that's where there is a lot of reluctance. But as I said, we are seeing the times changing and hopefully things will improve for the better.
Thank you, Mr. Way. Here's
Thank
hoping. Mr. Iyer, my next question is for you, sir. The retired Supreme Court Judge Justice Hemant Gupta recently expressed his views on how the appointment of arbitrators should go beyond former judges to include experts from other domains. Do you agree with his view, and would you nominate or agree to appoint a subject area expert in an arbitration?
Thanks, Gathi. 100% yes, we are in full agreement with the views of Justice Gupta. From the public sector side, I can't really say for the government, but from the public sector side, most of us are ready and willing to have subject matter experts as arbitrators. The difficulty which we find is, however, the stumbling block lies in case the matter goes to court for an appointment. Our experience is that judges by and large appoint retired judges as arbitrators. So even though we give names of persons who are subject matter experts as possible persons who could be appointed and who are in no way connected with us, our experience is not good. I mean, either the contractors are not willing or the court is not willing, and if at all they extend themselves a little bit, they feel that, you know, they have done a favor by appointing a lawyer as an arbitrator. So I don't know, I mean, we need a long way to go to get subject matter experts as arbitrators. Yeah.
Thank you, sir. To extend the same question to Gaurav, Gaurav, as an expert, in your view, would an arbitrator with subject matter expertise and not necessarily have a legal background, would that be a good idea? Would he be a good arbitrator, he or she?
Yeah, I totally agree. I mean, just to give you an example, recently I was part of an arbitration where the entire arbitration was around a very technical financial issue. And we had 3 judges. We had experts from both sides. There were about 6 to 7 expert reports. I don't think any of the arbitrators read those reports, right? I mean, I'm just saying. So it's you know, having one technical person, you know, like a hybrid tribunal, is something I think which should be the way forward. And similarly, I mean, with the government also, because most of these arbitrations, a lot of them are very technical, right? Either there's a delay issue or there's a oil and gas issue. I mean, you need experts to understand. And what I understand, I'm not a lawyer, but what I understand that arbitrations are like fact finding, right? It's not just a legal issue, right? It's a lot of fact finding that needs to be done at the evidence stage. So I really think having a technical expert, in not all arbitrations, but in quite a few of them, the large ones, specifically the ones which involve the government and the PSUs, I think it's a great idea.
Thank you, Gaurav. I think it also makes lawyers' lives easier when there is an expert involved, so consensus there. Yes, of course, Mr. Iyer.
See, I would like to say that the technical experts, they understand the problem very fast. So you don't need to waste time, one. Number 2, they are not so much bothered about procedure. And what we found is that the moment a judge comes in as an arbitrator, I think he thinks that it's a court. So both sides, you know, privately we beat our heads and we don't know what to do. And we are at a loss as to the waste of time. So that's it.
Thank you, sir. That was very insightful. Mr. Dsouza, my next question is for you. With the introduction of the Commercial Courts Act, has there been a shift in your view towards commercial litigation as a preferred mode of dispute resolution over arbitration, specifically in, say, for example, PSU contracts? And what factors do you think have influenced such a preference, if at all?
Good evening to all, and thank you, Gathi, for inviting me to this seminar. I don't think commercial courts are a preferred option, to be honest. I don't know why PSUs are now shifting from arbitration to courts. I mean, it's difficult to understand. I find clauses in contracts, PSU contracts now, where they put in a range, 20 lakh to 20 crore will be arbitration, either below 20 lakhs, so about 20 crores will go to the courts. They don't specify commercial courts, they say courts. I don't know what the reason is. Maybe the reason that the costs are prohibitive now in arbitration. Secondly, you don't get those kind of quality arbitrators. You mostly have retired people who are arbitrators. And generally the faith in the arbitration process may have somewhere been affected, the credibility of the process. I don't blame PSUs. Maybe there is something that we need to do, and arbitrators, lawyers, counsel need to do to get this credibility up again, where all parties feel safe and feel comfortable with arbitration. That's what I feel.
Thank you, Mr. Dsouza. Ms. Dave, a similar question for you. In your view, is commercial litigation under the Commercial Courts Act at par with arbitration as a mode of dispute resolution in terms of, for example, cost, efficiency, timelines, etc.? Was that the hope when the shift happened from, the shift is happening from arbitration back to commercial litigation?
So I won't say that it was meant to be a shift from arbitration, and well, it is not. That I will definitely say, for several reasons actually. And of course, I'm speaking of Bombay. I'm not speaking for the other states and cities. In Bombay, unfortunately, what we see is that the judges who have been assigned to hear commercial court matters also have been given other assignments. So they are not exclusively hearing commercial court matters. So they are not able to give that kind of time. Second, Bombay is known for its backlog, so that is always there. So I don't think that it has helped in the manner that it ought to have or should have or was thought it would help. And I'm definitely not seeing a decrease in the arbitration because of that, because I think clauses which have, parties still provide for arbitration because, as I said, people are realizing. And especially with the amendments in the Act where the disposal has to be within 1 year, I think that has worked fantastically. And I've experienced it myself, when we are trying to appoint retired judges as arbitrators, they actually decline the appointments saying that they will not be able to finish it, in 1 year. And therefore that 1 year timeline is actually very seriously considered. Though, of course, the extensions are provided for in the Act itself. But so the point I'm making is that arbitration is still the preferred mode, and I don't think the commercial courts. I'm hoping that it will actually help, but as we speak today, no. I think. If I had to recommend somebody, I would still recommend arbitration.
Yes, Mr.
Just
Dsouza.
add one more thing. Is it shifting from arbitration to courts is also counterproductive in the sense that the courts are already logged with so many cases. It's going to be a long time before your case is heard and claims are heard. It's going to be actually difficult for PSUs to retain their witnesses, retain documents for that long, and claimants are going to take advantage of that kind of a situation. In the long term, the costs and the risks are going to be very high for all parties. And the party that can withstand that and kind of keep their witnesses intact, the documents intact, and preserve their documents properly, will have the upper hand in the long term. Imagine a matter coming up after 10 years, a claim of say 100 crores or 200 crores. I'm a project company. My claims are never less than 100 crores. And if I have to go to a commercial court and that hearing comes up after 10, 15 years, a private company will spend a lot of money in preserving witnesses, documents, getting witnesses, even if they have retired. I don't know what PSUs will do in that case.
Definitely, Mr. Dsouza. I think when a couple of tenders that we've noticed which have included commercial litigation or gone back to it, I think maybe the hope was that commercial litigation under the Commercial Courts Act is going to be very different from what it has in fact turned out to be since 2015. So I think we can chalk it off to that.
So I'll just add what we are trying to do, and of course, as I said, everybody is hoping that it works. One is The pecuniary jurisdiction, we are trying, at least in Bombay, we are looking to increase, and that's almost there. The other one suggestion, in fact, if one would ask me, is, our court fees are capped. After a particular level, we are capped at 3 lakhs. Unlike all the other cities, where everywhere else it is ad valorem. Yeah. So that is something that should be considered, to prevent frivolous or adventurous litigation, as we would once say. So there are measures which could be adopted to improve the scene, but as we speak, I don't think it's kind of shifted.
That's a great point, Mr. Vai. Ms. Chinoy, my next question is for you. In the spirit of resolving disputes and not necessarily through arbitration, the government has recently, by recently I mean less than a month ago, passed the Mediation Act, which inter alia also applies to commercial disputes with the central and state governments and or its instrumentality. So as a first step, do you think parties are now likely to resort to this pre-arbitral statutory mediation mechanism? And specifically, since this has the effect of arresting limitation and offers like a time-bound structured process for resolving disputes, do you think practically it's going to make a difference? I mean, we're yet to see what actually happens, but what are your views on this new act and in resolving disputes with the state?
See, Gathi, in the first instance, having mediation, it's always great, right? Let parties sit across, try and sit and see if they can come to a conclusion quicker. Arbitration, as you know, it's document heavy, it's witness heavy, it's fact heavy, all of that, and then the arbitration award, it has to be written, it has to be reasoned. So mediation is a great sort of first, let's say, it's less procedure, it's less hassle, it's the ability to try and get that handshake across. So if it's mandatory, it would be great. It's not mandatory as yet. And so there are two parts to this. If it's between private parties, we always sit down in any case. It's not like we're going to say, no, if I had a dispute, let's say we won't say that we're going straight off to arbitration. We will sit across the table. We will try and see if we can mediate. We will try and see if we can resolve it. If we can't, then we go on to arbitration or whatever our dispute mechanism is. With PSUs, a lot of big tenders that we come across in Shapoorji, we have mediation written into our contracts anyway. And a lot of PSUs also do, I'm guessing, I would refer to that. But we do have a mechanism by which we are required to mediate. And mediate, there is a process, there is a procedure. Sometimes there's an institution also that's been recommended which we have to follow, or there's a choice, whatever it be. So we will try, but with a PSU trying to mediate, they will say that we will come to that table, but since it's not a binding process, since it's also a highly confidential process, the likelihood of us settling across the table is a little lower in that sense. But yes, it is a good first step. How far it goes, we'll see, because it's just a brand new act. I won't keep my hopes up too high, because a lot of other changes have to happen in the law for us to see where mediation will take us. It's a great first step. I mean, it is better than going down the whole arbitration route with the processes, the procedures, the costs, the time. It would be a great way to settle, but time will tell.
Mr. Iyer, I'm sorry, the next question is for you. The government has recently introduced the Vivad Se Vishwas 2 scheme for voluntary settlement of contractual disputes which involve the government and government undertakings. What are your views on this scheme, sir, and its effectiveness in resolving disputes? What are your views and your predictions for the future and your experience so far, if any?
We had the Vivad Se Vishwas 1 in which a huge amount of claims have been settled. Now we have got this contractual disputes thing which has come, Vivad Se Vishwas 2, and it does really help the PSUs. It makes it easier for us to settle because we got a benchmark already as to the kind of percentages are already prescribed. In case an award is made 65%, and in case of the 34 challenges also been dismissed or it has upheld the award, at that stage, the court stage, then 85%. and interest, of course, at 9% post-award. So most of the PSUs are by and large okay with it, provided that they feel that the claim and the award amount was reasonable to a large extent. So that's a big if. What we have experienced in the past few years is that there's a huge padding of claims, and which is where the PSUs have become very wary of arbitration. So we would prefer that if genuine claims come up, the PSUs will be very happy to settle. And in case it is padded up, then, well, it becomes a little difficult. Because once somebody has written on the file or given an opinion at some point in time in writing that, these kind of claims are not okay or something, then it becomes a little difficult for us to settle. Yeah.
Thank you, sir. Mr. Dsouza, the same question for you, but from a contractor's perspective, what are your views on the Vivad Se Vishwas 2 scheme and its effectiveness in resolving disputes?
Yeah, I mean, the intent is good, Gathi. We welcome the intent. L&T is a company which always wants to settle disputes. We don't get into arbitrations or courts. We'd like to avoid that and spend our energies on delivering and executing projects for the nation. But welcome step. I see a few issues in this, in the sense that one is there's a cutoff date of 31st Jan 23 put. That any award that comes before that date is only is the award that can be going for a settlement. I don't know why that date has been put. Maybe there's some reason, but it should have been kept open. Even if an award is challenged in the court, and again there's another date prescribed for 31st March. That is one. Number two, the 65% number is way too low. I mean, just imagine a company like us, we execute a project for 18 to 24 months, then there are delays invariably. It goes up to 24 or 28 months, and during the project we have a lot of claims that come. We don't agitate those claims, we don't get into arbitration because the project is under execution. And we want to maintain a good relationship with the customer. We don't want to disrupt the project. We don't want people from the project to be moving out and sitting and doing arbitrations. We wait for 24 months, 28 months, and then finally at the end of it all, we then start negotiating with the PSU. And the negotiations take their own time. Another 1 year goes by. So you spend about 33 years straight. Your money is stuck. Your costs are, your incurring interest costs, cash flows are affected. And then you think of going into arbitration. And then what do? You fight the arbitration for 18 to 24 months, get an award, and then you say, take 65% now. I mean, how do I even as a general counsel go back and tell my management that take 65% after all that we have gone through? So I think that number is an issue. Secondly, the language in the scheme itself, I was wondering what it means. It's a second part is where you get 85% is when there's a court award. I don't know when that court award is up. Whether it's after 34 is disposed of or in the interim stage of... because after 34 is disposed, I mean, if a contractor has succeeded, why would he take 85%? Because by then we have got the money, then the next step is only 37. And 37 doesn't impact us because it's very remote that anything is going to get reversed in 37 if it's a concurrent judgment. So these are issues that we have with the scheme. But I'm hopeful. I mean, the other thing that is missing in the scheme is I think they should have covered disputes prior to award or while the arbitration is going on, before the award is passed or even before you get into arbitration. If they would have covered that, I think 65% would have been welcome.
At that stage, before you've incurred that many costs.
Absolutely.
Here's hoping for Vivad Se Vishwas 3, which resolves all these issues. Gaurav, my next question is for you. As an expert, what is your general experience been in arbitrations where the government is a party, whether as a claimant or as a respondent? And more specifically, in your experience as an expert witness in disputes involving the government, what are the advantages and disadvantages of institutional versus ad hoc? And what factors do you think influence such a choice? And do you see it changing one way or the other?
Yeah, so see, I mean, there's a positive change for sure as far as we are dealing with the government. I mean, a lot of the construction arbitrations that we do in India domestically, almost all of them are against the government. But it's been very heartening, at least for me, last two years, at least there have been 3 arbitrations which are very high stake, where the government has hired us as experts. Because usually it's a very cost-driven, I know the PSUs, I mean, their hands are tied. It's very cost-driven, but I think when the stakes are high, I think that change is happening and is important. I mean, just to give you an example, in a recent arbitration that I represented the government for, one of the state governments, it was over a $2 billion claim. Now, if we don't defend that, to me, it's like it's my tax money. I mean, it needs to be defended, right? Like sir was saying, there's a lot of padding up and all of that happens. I think it's important that happens. I mean, to me, hiring experts, not every time, but I think it's important for matters which are large, which are huge, and which require some technical or financial assistance. That's number one. Number two, I think the other thing is, working with the government. I mean, these 3 arbitrations have really shown us a lot of. I mean, these are issues, but they're getting better. But like document management, most of these contracts or most of these, contracts are maybe 7, 8, 10 years. Like delays are huge a lot of times, and you don't have ownership of documents. There is a site involved, there's a head office involved, the legal, the contractual. I think we struggle a lot. I mean, even with the private contractors sometimes, but with the government, it's another issue. I think that's something. I think they are also learning the way they are operating now with the contractors. They're keeping the paperwork better. I think that's something which a lot of companies are. The contractors are doing it, right? The claim management, or they're getting people, professionals, to come and figure it out. When they are ready, when something happens. I think that's something that, in my experience, was a challenge. Because you're working on half information. You're trying to piece the puzzle. I think that's another issue, but it's definitely improving. I think somehow we need to find a way. The entire environment of the PSU, because then you understand even the decision makers are like, for decision making is another thing. While our contract, in that arbitration that I just mentioned, I don't think we still have a contract with the government. It's just an LOI kind of a thing on the mail, because I mean it goes through various kind of levels and all of that. Nothing is easy there. I think these are the challenges that I see, but frankly I am positive because I am seeing that kind of a change happening with the government, and I hope they defend the PSU and they defend with good lawyers and with good experts. I think that's something which is required, especially the high stake ones. As far as the institutional versus ad hoc, for me, I think, like Bindi said, that cost is something that everybody talks about, but frankly, it does turn out to be more expensive, a lot of these domestic arbitrations. Just to give you an example, like, I had written a report and I was supposed to be cross-examined for a day, and the cross-examination went on for 5 days, just one witness. And obviously somebody's paying for it, right? I mean, somebody's paying for it, the government, whoever, the client is paying for it. So to me, I think it's a very inefficient place for as an expert, because once you're given a procedural order in an arbitration which is under some rules, this is what it is, right? Here, it's open to the tribunal, it's open to the the person who's cross-examining you. I mean, it's very subjective. So frankly, I do think going forward, it's important that more and more arbitrations are under something like the MCIA or ICC, whatever institution there is, and I think even the government contracts and all should include that, because especially in domestic, if you look at the domestic arbitration, most of them, there'll be a PSU or a government involved. So I mean, that's what I have to say. Thanks.
Thank you, Gaurav. Ms. Chinoy, I think from Gaurav's answer, the next question is that we all stop at, oh, unfortunately, the contract does not have an arbitration clause, so we cannot do this anymore. But in fact, that is not the case, because in an arbitration agreement that does not provide for institutional arbitration, an arbitration agreement, you can consent to availing administrative assistance by a suitable institution. So there is a provision under Section 6 of the Act which allows you to do so. It is just that you need consent. Only in this case, it is post-dispute. In your view, is that something that you have seen in your experience, people actually post-dispute agree to an institutional arbitration? Have you ever seen something like that? And why do you think people don't go in for this and they feel like the agreement is a hard stop?
Honestly, Gathi, when the contracts that I see, most of them, the institution is written in. And there's not that much leeway to play with it. But if you ask me if it wasn't written in and somebody come to me and said, shall we do an institutional arbitration, then I would just have to look at the facts. I'm not going to say yes straight off. I do understand that it could be cheaper, it could be faster, it could be more efficient, but which side of the table am I on? Am I in the right, am I in the wrong? What are the kind of claims that I want? Is it that I would have to pay out, or am I at the receipt? I mean, there are so many things that go into this strategy that I would have to consider before saying yes or no. And then the kind of institution that they want to propose, the kind of fees that institution has. Every institution is not built equally. So the fees themselves would play a part, and then depending on that, the kind of lawyers that I'd have to choose. All of these have to be considered into the merits of the case. So saying, yeah, I'm going to do institution doesn't work that way. Would I do ad hoc? I would prefer not to. That, yes, I would say that would be my personal opinion. Because in terms of timelines, in terms of how to go forward, in terms of execution, all of that, ad hoc does become a little more difficult. But again, strategy is really, really important. Where do I want? What do I want? How do I want? Everything comes into play.
Thank you, Mr. Roy. So it's not a simple yes or no.
Sorry, Gathi,
Yes,
I'll just
Mr.
add, since you asked whether we've seen this happening.
Yes.
Fortunately, I have, and in heavily contested matters. But I think it's very important to have a reasonable and a sensible law firm or counsel on the other side. Because while clients will think, like Zarina mentioned, whether you want to agree, not agree, whether you're on the right, wrong, and maybe not everything is black or white, but I guess there's different leverages playing. But if you have a practical and a sensible law firm, and I want to tell you of two examples, not very recently, but since 1996. One is where we had a dispute clause arbitration, but with 3 arbitrators and no institution specified. And fortunately, and we were representing an individual against a MNC, so we were like not nicely balanced either. But fortunately, the law firm on the other side and the senior advocate appearing, we could arrive at an agreement. From 3 arbitrators, we agreed to 1 arbitrator, we agreed to an institution, and we had an award in less than a year's time. Another example was where we were representing a client who had, I think, about 40-50 separate agreements with different group companies with an IT service company on the other side. So the principal parent companies, would have entered into some sort of a master agreement, and then there were individual agreements, amongst those 40-50 entities, and there was some sort of a global dispute which had arisen, and I was to be the claimant, and I would have actually been required to file or, start some 50 odd arbitrations. Consolidation, of course, was one option that we would have had. But we actually, discussed with the law firm on the other side, and we said, look, I understand that I will end up spending, but so will your client. And the firm was very sensible, and we made parties enter into a new arbitration clause. All those 40 entities on one side and our 40 companies on one side. Of course, it took some time to get there, but and not all were Indian. So, we had other laws kind of getting involved and lawyers getting involved and all of that, but we actually achieved that. So what I want to tell you is, of course, from the several matters that I would have done, these are like 2 examples, but it is possible if you have sensible and reasonable advocates, I think.
I think it's very heartening to see that you can actually separate the dispute from the dispute resolution instead of mixing the 2 up. And I think my final question, at least from me, and then I'll open it up to the audience. Ms. Dave, for you. The government has recently constituted the TK Vishwanathan Committee, it was in June 2023, to discuss reforms in arbitration law. In view of our discussions today, what reforms do you think are needed to improve resolution of disputes, specifically where a government or a state-owned entity is involved?
So the one that I really connect with, because I've experienced it on both sides and not necessarily only when the government is on one side, is some sort of a power to the courts to be able to modify the award under 34. So while I understand that this was there under the old act and there's been a conscious decision to not have this, and there are judgments after judgments which say that you cannot read that into 34, though parties have tried that. But that is something, because I have seen a lot of arbitrations where the awards get set aside and you then kind of start de novo. So, and as I said, I've been on both sides and it's a huge cost, for parties. So of course, I understand that it will open the floodgates and you could have more problems on your hand, but the way the entry to 34 is now restricted, and with the conditions of deposit and all of that, I think we could have some similar tests being put in place. And I really think that the court should be empowered to modify, is one recommendation that I definitely would like to make.
Other than the Supreme Court in its inherent power?
Yes, apart from Supreme Court. Yeah. That they've exercised, but then by the time you've had 5 rounds, arbitration 34, 37 and then...
The cost has gone up so much.
Absolutely.
Is there anyone who would like to ask a question to anybody? If you could please introduce yourself, and if you are directing it to a specific panelist, then if you could please name them.
My name is Prakash. I'm a third year student of law at MCIA.
Would you like to come forward?
I am Prakrit. I am a third year student of law at MNLU. So my question is, even though lately it has been getting better, we have seen a trend where state-owned entities are usually reluctant to submitting disputes wherein they are involved to getting adjudicated by a private entity or a tribunal, more so if it's a foreign tribunal. In those cases, usually they have some sort of legislation which requires them to take a previous approval. I think Iran could be an example where they had some sort of a constitutional provision where they wanted that every time any state-owned entity or state submits to an arbitration, there must be a previous approval that might be sought. And that creates a lot of confusion between whether or not there actually has been an approval on part of the state-owned entity or not. And later, when they see that the arbitration is not really going into their favor, they pull in this card by saying that we never had a valid arbitration agreement. So how do we really find a solution into this?
Would you like?
I'm not sure I understood the question, but see, contracts in India with PSUs, the contract clauses, arbitration clauses are very robust. There has never been a dispute that the clause itself is not valid or something like that. In fact, recently the Supreme Court upheld IOCL's very elaborate clause on arbitration, though it had so many layers to it. And it gave IOCL the complete discretion on whether to decide whether a particular dispute will go into arbitration or not. Still, the Supreme Court permitted it. I don't think we have that problem. This must be somewhere in Iran, and
I think investor-state disputes is what you are referring to.
Yeah, largely investor-state disputes.
Okay. Sorry, I can't throw any more light on that.
Yes, I think the question. So I think the focus is this discussion has been more on domestic disputes, but for investor-state disputes, I'm sure there's a different panel that you can attend tomorrow who will be very happy to answer your question. Is there anything, any other question that anyone would like to ask, or I have more questions that I can ask? Yes, please.
Good evening, sir. I'm Saparnika. I'm an associate at Bharucha and Partners. My question is directed more towards Mr. Gulati. So you mentioned how PSUs are under pressure. They have to keep in mind costs when it comes to arbitrations. because more often than not, arbitration starts mostly in the courts with the appointment of the arbitrator or a Section 9 application. So PSUs are very wary, in my personal experience, where they are very strict that we will not have any interim applications whatsoever. Let's just go straight on, let's just head. To that extent, sir, to what extent would you recommend bringing in witnesses in a highly technical dispute? Because that would just prolong it more and more, where we would want to then re-examine that witness, or most times than not. Suppose it's a construction dispute, the person who was in charge of the work from the PSU has already retired by the time the dispute has started, or he's posted somewhere else. So there's a concern there for the company that you have to now arrange for the transport, and if the witness examination is not completed in a certain amount of days. And PSUs are also very wary nowadays. In the judgment of ONGC versus AFCONs, we saw how detailed ONGC's arbitration clauses are. So with that kind of pressure on PSUs, how do we as their lawyers recommend them in terms of witness examinations?
Yeah, I agree. The PSU, whoever is taking decisions in the PSUs are under a lot of pressure. That's for sure. It's not a simple thing. But like you said, a lot of these disputes are very technical in nature. Normal construction will have a delay issue, right? It will always have a delay issue. And unless you defend it well, like sir was saying, that there's a padding from the contractor side, or there's some, because you're not defending it properly. I think it's really critical that the government starts doing that, or the PSU start doing that. Despite of, and I don't know, the lawyers here can answer how legally it can be easier for them. But I do believe that right now also we are doing an arbitration for a global contractor against the government here, and we know. We are independent experts. We are giving away, but we know that usually the government will not get an expert which is strong enough to kind of even get the right point out of the arbitration. What is the technical issue, and what is the answer to that? Even defend that or fight that. That's something that is required, according to me. But I don't know what the legal issues are for them. To be able to do this.
First thing is pressures are of course there, but that is there for everybody, and we manage it, so that's fine. We are okay with dealing with arbitrations fast. The issue which I find is that the arbitrators want to go into evidence. At that time, it becomes a little difficult sometimes, because the persons who handle the contract, we are in a transferable job. So most people, because of some vague concept of vigilance, that a person should not be holding on to the same post beyond some years. In PSUs and government, they keep getting transferred, whether it's necessary or not. So what happens is, the guy who was actually on the field or who was actually handling the contract, he is no longer available at this particular spot and easily available. So the new person who comes in, he has to go through the records and the files, and then he tries to make up. So there we have an issue on that. And yes, we are ready to go to institutions also. The mindset is changing. At one time, we had the mindset that it should be our employee who should be an arbitrator. People have moved from there. We are willing to have outside people as arbitrators. The mindset today is only that we are willing to go fast also, but as long as the claims are reasonable, well, fine. Things will be fine. Okay. So I am coming down to that. I am coming down to that as a issue.
Thank you, sir. Yes, of course, Mr.
So just to add, reasonableness is decided on both sides of the line, sir. Just to say that, I don't see PSUs ever admitting to any delays. They believe that the contractor is always delayed. So, it's a question of both sides, sir.
Since we are on this issue, and you're lawyers, I think you may benefit from our experience. What is reasonable is, we expect that a contractor who, let us say, takes a 1 crore contract, we'll get into nitty-gritties a little bit. So he takes a 1 crore contract and 80% of the work is done, and thereafter he hesitates because he has financial problems or something like that, or some issues he experiences in the contract itself while doing it. and he goes. Now 80% of the work is done, and let us say he's paid for largely on the 80% work, and 20% of the work is remaining. Okay. Now how much can a man claim for the balance 20%? So we expect that most people who are doing business are wise, that in a contract of 1 crore, we don't expect a person to expend 2 crores or something. We don't expect a businessman or a contractor to be that stupid. So a person, we expect that if it is a contract, he has spent 80 lakhs and he's got 80 lakhs, on the balance 20 lakhs which is left unspent, at best you can claim maybe 5 lakhs or 10 lakhs or something like that. But if a person instead of 20 lakhs he wants to claim 2 crores, then well, that's unreasonable.
Thank you, sir. I think we have time for one more question. Is there someone who... gentleman here, please.
Okay. Should I pass the mic to him? Because I was...
Yes, please. I thought we'll have some questions from this side.
Sure.
Good evening, everyone. I'm Sudarshan. I'm an associate at Federal and Company. My question is more related towards the Commercial Courts Act rather than arbitration. So recently the Supreme Court has said that the pre-institution mediation under 12A is mandatory. Now, if the parties are commercial parties and there is going to be a commercial dispute, do you think that this creates an unnecessary procedural hurdle for the purpose of the dispute? Because a party will not institute commercial litigation proceedings if there is a possibility of a settlement.
Anybody can...
Sorry, what was the question again?
Why
will you think that that's something that's not going to work?
Is 12A even really necessary? Did they have to make it mandatory?
I agree. And in fact, in most of the matter, there's the carve out that if you're applying for interim reliefs, then you don't even have to go through that. And therefore, in all matters, and Bombay, whether we like it or not, has become an ad interim court. And there won't be any matter that gets filed where you don't apply for ad interim. So yes, I agree. It is a bit pointless. And if parties genuinely wanted to mediate themselves, they would have as Zarina mentioned, private parties would definitely try that before, getting into court. So yes, I agree. But having said that, maybe, it's not that, we can speak for all kinds of disputes. Maybe a lot of times what does happen is filing of a proceeding itself acts as some sort of a leverage where the plaintiff is not necessarily seeking to, snatch some order or something, but because, you have a claim filed against you, you have to report that and all of that. So it does come with its own problems, and maybe the earlier attempts at mediation may not have worked. So maybe it may have helped. I would presume that the legislature has put this provision, examining and keeping things in mind. So while, yes, I've yet to see it actually work and help, but maybe it's helped.
Thank you.
Yes.
I have a different view. I think it'll help. You need to have mediation, and it's time-bound mediation. I think 60 or 90 days that is prescribed. It'll help tremendously in getting the parties together. And what happens is, if you have a mediator who's an expert, who understands the issues, the technical issues, the commercial issues, he can put forth, get the parties to see reason and get a settlement done. I have actually used mediation in some shipbuilding contracts with good results. So I think that's really is welcome.
Thank you.
I think as the last question, I'd like to ask everyone if they believe that Section 29A of the Arbitration Act, where you can extend the timelines for concluding arbitration, whether you think that is working in today's date. Because do you think that the courts are giving timeline extensions without properly applying their mind to what has happened so far, how much time, depending on who the tribunal is, etc.? Or do you think that it's something that is working perfectly fine and it's keeping the arbitration timelines in check?
In my experience, in my experience, I think it's working extremely well. Both, it acts as a pressure on the arbitrators, and I've seen it on both sides. I've had the benefit of being an arbitrator, and I know I'm very conscious of the timeline. And I have seen it in other matters where the arbitrators themselves, are very conscious They want to, and as I said, in fact, not just after starting the arbitration, I've seen this. I've seen the arbitrators actually take some sort of a back seat, and otherwise the tendency was to take as many arbitrations and matters. You know, like how we lawyers function. I mean, you'd want more the work, the better. But I've actually seen and experienced arbitrators refusing arbitrations because they are conscious of the timelines. So one is at the arbitrator level, definitely, and secondly, even at the court level. I've seen instances where, unnecessary adjournments were granted, and that's why there was not much progress. And we've had, I'm not naming the judges, but we've had judges actually change the arbitrators. So, yes, I think it's working very well.
So we just did a section 29, and we had to give details of why we needed that extension, and we had to put in a fair bit of detail. And the judge did ask us, we did have to substantiate that. And so I think that they are very, very aware of the timelines that they're extending. And so the reasons have to be cogent, they have to be clear, and otherwise I don't think we just get it for the asking.
I had one more example, this matter where we had a tribunal of 3, and we'd not made much progress at all. And we were in an application under 29A, and the Bombay High Court judge actually, and we kind of disbanded the entire tribunal, and we then were, if I may say so, kind of pushed into having just a sole arbitrator.
So they acted like a super institution who's governing the arbitration. Absolutely.
I have had mixed experiences. I mean, sometimes the arbitrators themselves are very conscious of the time limits and finish the arbitrations very fast. I've had arbitrations close out within 12 months also. But on the other hand, there are arbitrations where you keep getting extensions from the court. And what happens if on the tribunal you have 2 chief justices retired? So, and you go to the court for an extension, no court is going to refuse that extension. And it has happened to us. Extensions have been granted for the asking without any reasons, without any delays.
I think timelines are one thing that everybody is very particular about in arbitration and generally in resolving disputes. So that is something that we hope does not change with frivolous use of 29A or granting. I think with that we will close this panel discussion. Thank you everybody. Thank you so much to my stellar panel for being so patient and giving us the time. Thank you everybody. Hope you had a good time. Our next event is a debate. I would love if you could join us, and we'll take a short break and then reconvene. Thank you.